Hello. Um, Deborah, can you hear me now?
Yes.
All right, we can go ahead and get started. Thank you all for joining us today. We have Deborah Wagner here, Senior Attorney, Legal Aid Society of Southwest Ohio, presenting on Ohio Medicaid for Children. I just wanted to kind of go over a couple of house rules. We have the audience muted. Um, But I would also request for you all to mute your lines so that we don't hear any background noises. Star 6 to mute. On the left-hand screen of the Skype screen, you will see a chat box. And please type in your questions and we will get to them towards the end of this webinar. Um, and with that, we are going to record this webinar, and we will have the recording of the webinar available later in time. And I will also try to send in the PowerPoint presentation to all people registered. With that, we are going to get started. Deborah, I'm going to just share the screen right now. And you may not be, I think the only problem is you may not be able to kind of like change the slides. So let me know, switch to the next slide and I can do that.
Okay. Thank you very much.
Mm-hmm.
And thank you for your kind introduction. Welcome, everybody. Today we're going to do kind of a broad overview of Ohio Medicaid for Children. And then we're going to talk specifically and in some detail about the appeals process and the types of issues that you can appeal for Medicaid. So let's go ahead and get started with the next slide, which is an overview. So Medicaid is jointly funded. The federal government and the state government both contribute funding to the program. It's health insurance, and it covers low-income and needy people, but there are many different Medicaid programs. We're only going to talk about a few of them today just to give you a feel for the types of Medicaid programs that children commonly have. In the state of Ohio, the Medicaid program is managed by the Ohio Department of Medicaid, but it's administered by the county Job and Family Services offices. So, for example, the Hamilton County Job and Family Services office would be where Hamilton County residents would go to deal with Medicaid issues on a local level. Today, we're going to really focus on three parts of the Ohio Medicaid program. We're going to talk about who's eligible, how to apply, and what to do if you're denied or they propose termination, or what the appeals process really is. So the next slide talks about...
Deborah, sorry to interrupt. I think I want to just quickly make sure that our audio is clear, so I have to go back to the Skype screen for a minute.
Okay.
Just see that everything is... Yes, I think our audio is clear and
okay.
We can hear you. I see a chat, somebody saying we can hear you. All right. Let me go back to the next slide.
Thank you.
Yes.
So this slide really covers what types of services Medicaid is going to cover for children, and it's very broad. It includes everything from your doctor's visits to emergency room care, hospital services, prescription drugs, dental and vision care, both are included. One special thing that's included in Medicaid for children that is not included for adults is this item on here that's called Early and Periodic Screening, Diagnosis, and Treatment, or EPSDT. This allows children to get more frequent doctor's visits for routine screenings that children need. And they look for all kinds of things, and they may provide treatment for things that wouldn't normally be covered by Medicaid for adults. So a common example of something that I see covered by EPSDT is orthodontic care. So if a child has teeth that are misaligned and it's having adverse health consequences, they would be screened for it, and they could actually get treatment for that orthodontic care. All of the services provided under Medicaid must be medically necessary, and some services will require prior authorization from Medicaid. So now we're going to talk about the Medicaid programs for children. Again, these are not all the programs that children may be covered under. This is just a sampling of the most common ones. So the first one is that if a child is getting SSI, so next slide, please. The child is getting SSI, which means that they've been found disabled under the Social Security definition, and their family qualifies financially, meaning that they have very limited income and resources. Those children are automatically enrolled in a type of Medicaid called Medicaid for the Aged, Blind, and Disabled. And this is because these children qualify as disabled under the Social Security rules. This program has full coverage, and there are no out-of-pocket expenses for the family, so this is very comprehensive coverage. Children in low-income families may qualify for a number of different programs, but the common ones you'll see are Healthy Families, which are for families with income up to 90% of the federal poverty level, and there must be at least one child in the household that is younger than age 19. Another common one is Healthy Start, which is oftentimes referred to as CHIP. Healthy Start's what we call it here in the state of Ohio. If a child is uninsured, meaning they don't have other medical insurance, up to age 19 and their family income is below 206% of the federal poverty level, they could qualify. Even if a child has health insurance, so let's say a parent has an employer-provided health insurance program, but if their family income is below 156% of the federal poverty level, that child may also qualify for Healthy Start. And so what would happen is that the parent's insurance would be the primary payer, but then Healthy Start could cover any co-pays or services that the primary health insurance does not cover. And sometimes we all know health insurance plans may have extremely high deductibles or high co-pays that really just make it not affordable for low-income families, and that's what this program is designed to cover. Also, Healthy Start covers pregnant women and families with income up to 200% of the federal poverty level, and then it will also cover that newborn child for the first year of life. The next slide talks about kids who need some higher level of care. So these are kids who either need long-term care in an institutional setting, such as a skilled nursing facility or an intermediate care facility. Medicaid can cover the costs of that care if the family is financially eligible. Some kids may need a skilled or intermediate level of care, but that care could be provided to them in their own home. Those children may qualify for what are called home and community-based services, or HCBS waivers. Again, the family has to be financially eligible, and in addition, there has to be a waiver slot available for that child. This is a program that allows kids to receive things like some skilled nursing, personal care attendant services, maybe some respite care for a family of a child with special needs. There's whole packages of services that are provided under waivers. For both of these programs, the child must be categorically eligible for Medicaid, meaning that they're getting SSI or they follow under one of the other categories we're talking about today, or there is a special income rule for long-term care Medicaid that could allow that child to have coverage through one of these programs. The next slide talks about non-U.S. citizen children. So usually in order to qualify for Medicaid, you have to be a U.S. citizen or you have to fall into an eligible immigration category. These two programs are examples of programs available to non-U.S. citizen children. So the first one, the Alien Emergency Medical Act, or IEMA, covers only acute and medical emergencies. And you have to be eligible for Medicaid financially and meet all the other criteria. The only thing you don't meet is the citizenship or immigration status. And what IEMA will do is cover just that life-threatening emergency. So, for example, we had a case recently where a family was in a very serious auto accident. People had to be extracted from the vehicle. People were rushed to the hospital, and they had life-threatening injuries. They required immediate surgery. Several of those family members were not U.S. citizens, and for those family members, IEMA was able to cover the costs associated with that emergency care. It's not going to pay for the next year's worth of physical therapy, but it did cover those immediate emergency expenses. Another program is Refugee Medical Assistance. This is for people who qualify under the immigration laws as either a refugee or an asylee. They have to have income below 100% of the federal poverty level, and it's going to cover them just for the first 8 months after they either enter into the U.S. or after they obtain the refugee or asylee status. And so this just allows those people who are transitioning here to have some health coverage to address some immediate medical needs until they become established, and the idea is that they should find employment and other ways of obtaining health care. So let's talk now about how to apply for Medicaid in Ohio. So there are 3 different paths you can follow to do an application. You can apply online, and I've given you guys the website here that you could use to do that. You can go through and do the entire application online. You can call the state Medicaid hotline, and I've given you guys the toll-free number here. They will take applications by phone, or you can go in person to your county job and family services office, and they will take an application from you in person. If you're going to go in person, it's important to take the application forms with you. So the next slide, please. So the forms can be found online, and I've given you guys a website for where you can find the forms. If you're going to be applying for not only Medicaid, but also maybe food assistance, maybe some cash assistance like Ohio Works First benefits, you would fill out the JFS 7200 form. If you're applying only for the Medicaid, that's the only assistance that your family needs or that the child needs, then you would fill out the Ohio Department of Medicaid's Form 7216. When you do apply, the next slide talks about some verifications that Medicaid applicants are going to need to have. So I always encourage folks when they're looking at applying to have these verifications ready and available. The first one is proof of U.S. citizenship or immigration status. The second thing is a social security number if you have one. Now, like I said, some of those folks with IEMA or the refugee assistance, they may not have a social security number, but if you have one, you need to have it available. Proof of Ohio residency, that can include everything from an Ohio driver's license to a lease that lists you as a household member of an Ohio residence. It could include school records for children showing that they're enrolled in school here. And then you're going to need proof of income for the family. And for some of the programs, you also need proof of resources or assets, so money in the bank, stocks and bonds, things like that. Let's talk now about how these applications are processed. So the County Job and Family Services Office has 45 days to process the application. They may send a letter, though, saying, hey, we need more information to process your application, and here's a deadline we're giving you to get us that information. It's really important that people get those verifications together and get them submitted promptly, because if you don't, that can be a basis for denying an application. If somebody needs help getting the information, they can ask the County Job and Family Services Office for help. And at that point, the county has an obligation to do their best to help you get information. So, if they ask for an employment verification and you've asked your employer and they are ignoring you and they're not giving you the information you need and they won't fill out the form, you can ask the county for help and they can ask the employer. And sometimes employers may be more responsive to a government agency than they are to their employees. If a child needs either long-term care or those home and community-based services, a waiver like we talked about, then a level of care assessment must be completed. And those applications can take longer. They can take up to 90 days because either the County Board of DD or the Council on Aging is going to be doing a level of care assessment, or if the child's in a facility, that facility's got to do the level of care assessment showing that that child needs the additional services that are provided either in a long-term care facility or through a waiver. So let's talk about what happens now if your application is approved. So the great thing is you'll get an insurance card right away. It's a monthly insurance card at first, because at first you'll be enrolled in what's called fee-for-service Medicaid. But for most folks on Medicaid in Ohio these days, they're then going to get a letter telling them that they get to select a managed care plan. And once they select a managed care plan, then they'll get a permanent card instead of getting the monthly insurance card. And these cards will come from one of the managed care plans in Ohio. These are the managed care plans that I've listed here for you: Buckeye, Molina, United, CareSource, and Paramount. And depending on where you live in the state may determine which of these managed care plans are available to you. Everybody on Medicaid is required to do an annual recertification, so you're going to verify that eligibility information again. And also you're required to report changes within 10 days. And this is really important. So if you've got a child on Medicaid and their household income is one of the bases for their eligibility, if a parent loses a job, starts a new job, gets a raise, anything like that, that's a change that would need to be reported to the County Job and Family Services office. So let's talk now about if your application is delayed or denied. So let's say it's been 60 days since you submitted your application and it's not for waiver services, it's not for long-term care, or if you're denied, you do have a right to appeal, and that's what we're going to spend the bulk of our time talking about today. So we're going to start now talking about Medicaid appeals in Ohio, and we're going to walk through the process in some detail. So the first thing is that if you're in a managed care plan, which most folks in Ohio are, you have to go through the managed care plan appeals process first. So there are many different types of adverse determinations that a managed care plan could make. They could deny service, they could limit service. So for example, if the primary care doctor says your child needs some mental health counseling and that they need to go for a while, but the managed care plan comes back and says we're going to authorize 2 counseling sessions, that would be a limited authorization. You can also appeal if there's a reduction, suspension, or termination of services, a denial of payment in whole or in part for a service, or denial of a request to dispute a financial liability. So if you're saying, hey, I don't think I'm responsible for that bill, and here's why, those are all things that you can appeal. So when a managed care plan makes one of these decisions, they're going to issue what's called a notice of action, or an NOA. And that will be sent to you in the mail, and then you can start the process. So let's talk about what a notice of action is and what it's going to include. So it's going to talk about the adverse benefit action that the managed care plan has either taken or intends to take, the reason for that determination, the member's rights to file an appeal and instructions on how to do that, and your right to receive what's called aid pending if applicable. Aid pending means that you're already getting some benefit and the managed care plan is talking about stopping that benefit and you want to continue to get that benefit during the appeals process. That would be an example of aid pending. So let's talk now about the process for appealing a notice of action. You've got 60 days from the date on the NOA to actually file your appeal. But if you want to get that aid pending, you're going to have to file your appeal within 15 days from the date on the notice. The benefit they have to have time to stop things in motion. So you've got only 15 days if you want aid pending. Aid pending is not going to get you a new service that you've not already received, but it will allow you to continue services or goods that you are already receiving. You can appeal either orally by calling your managed care plan, or you can appeal in writing by sending them a letter. So let's talk about what happens after you appeal the notice of action. So once you file your appeal, the managed care plan has to provide you with a reasonable opportunity to present evidence and allegations of fact or law in person as well as in writing. And so what this means is that you or your authorized representative must be provided the entire case file and all the documents that they used in making that adverse decision. And while they generally aren't going to schedule a hearing or anything like that, you can ask for a meeting to present evidence verbally. So in your appeal request, if you want to have an interview or a meeting, you should ask for that. And that would be your chance to testify and present any evidence that you want to tell them about. So certainly documents are one type of evidence, but sometimes you want to tell the story of what happened, and this meeting would be a way to do that. So let's talk about managed care plan decisions. The managed care plan has to make a decision on the appeal within 15 calendar days from receipt of the appeal. You can ask for an expedited review if you feel like the member's health would be put in jeopardy by the adverse benefit determination. So if they say that they're going to stop occupational therapy or they're going to stop providing oxygen or something that's going to seriously affect a child's health, you can certainly ask for an expedited review. You can also ask for additional time, extended up to another 14 calendar days, so pretty much a month, if you need additional time to get together evidence or information that you want to submit. So maybe you think a letter from the doctor or some more medical records might help make the determination. You looked at the file that they were required to provide you and they were missing something and you want to submit it, but you need time to get that evidence. You can ask for additional time. Please know that the managed care plan can also ask for an extension of time, but their request has to be approved by the Ohio Department of Medicaid, and that's only going to happen when the Department of Medicaid finds it's in the best interest of the member. So the managed care plan can't just drag their heels. They have to have a good reason, and it has to be in your best interest to extend the deadline for a decision. So once the managed care plan makes a decision, it has to issue a written notice on the resolution, and it has to, if it's in the favor of the member, then the managed care plan shall authorize or provide the disputed service as expeditiously as the member's health condition requires, but usually that means within 72 hours from the appeal resolution date. So once they've decided, if they've decided in your favor, things are going to happen pretty quickly at that point. If the appeal resolution is not wholly in the member's favor, the written notice is also going to have to include some information, and it's going to have to include your right to request a hearing through the state hearing system, which we're going to talk about. It's going to have to explain how to request that hearing, and if applicable, how to ask for that aid pending. And it's got to include information about oral and written translation services. So if somebody is not a native English speaker and they want the decision and their appeal rights in another language, they have to be given information about that, and also information about how to get somebody on the phone as an interpreter if they need that in part of the process. All right, let's talk about if you've got a decision from your managed care plan and it's not wholly favorable, and you're going to go to the Bureau of State Hearings, which is a state government agency, what that appeals process looks like. So let's walk through that together. So the first thing is that you have 120 days to request a state hearing from the date that you get the appeal resolution notice from your managed care plan. If you received aid pending during the managed care plan appeal, then you want to continue getting that, then you should appeal within 15 days. So 15 days is really your magic number in all of this. If you're getting some good or service and you want it to continue while they're figuring all this stuff out, it's 15 days to file your appeal with the managed care plan, and it's 15 days to request a Bureau of State Hearings appeal. So it's important to know that 15-day number, and that's why I've got it bolded there for you. So let's talk about Bureau of State Hearing appeals. So the County Department of Job and Family Services is going to issue the Medicaid Notice of Action on behalf of the Ohio Department of Medicaid, and it's going to tell you, again, what the decision is. So it's going to say, you know, you've been denied prior authorization for your orthodontia treatment. The most likely Medicaid action you're going to see is a termination or a denial of benefits. So if it's a denial, please note that there will have been no managed care plan involved. So you'll be appealing directly to the Bureau of State Hearings. If it's a termination, if they're going to stop Medicaid coverage that you've already had, chances are that you've had a managed care plan, and so your first notice of action will probably be from the managed care plan, and you'll have to go through that appeals process that we just talked about with the managed care plan before you could get to the Bureau of State Hearings. One more thing on that left side, please. No problem. That was just what I said. Okay, I covered it. Next slide, please. Sorry. So your deadlines to request a Bureau of State Hearings appeal. So you have 90 days to request a hearing from the date on the notice of action from ODM. So if you're not getting a decision from a managed care plan, you've got 90 days to request a hearing from the date on the notice of action that came from Ohio Department of Medicaid. And of course, we all know how many days do you have if you want aid pending? 15 days. That's the standard. So if you want to keep the benefits you already have while the appeal is pending, 15 days from the date on the notice of action. All right, let's talk about what's going to happen before your Bureau of State hearing. So the first thing is that the Bureau of State Hearings is going to schedule a hearing usually 34 to 45 days after you request it. So you're going to be waiting 1 to 2 months to get your hearing. You're going to get a hearing notice, and it's got to be mailed to you at least 10 calendar days before the hearing date. So they've got to give you some advance notice. So you don't have to worry about getting a notice in the mail today saying you have a hearing tomorrow. The hearing notice is going to tell you what the issue or issues are on appeal. It's going to tell you the date, time, and location of the hearing, or if the hearing is going to be by phone. You can ask the Bureau of State Hearing to schedule the hearing by phone in your hearing request, or the department may ask to do it by phone if that's what's easiest. If you're going to go to your local office, make sure that you allow enough time to get to your local office to go through any security screening and to find the location for state hearings. You want to be there in plenty of time to make sure that when they call your hearing, you're ready to go. If you do it by phone, you're going to provide a phone number to the Bureau of State Hearings. They will call you and they will call the county, and any other parties who are going to participate will be there by phone. So either the agency, so either Job and Family Services or the managed care plan, if you had one, has to prepare what's called an appeal summary, and they have to get it to you at least 3 business days before the hearing. And what the appeal summary is it's really all of the evidence that the JFS office or the managed care plan used to make their decision, and they're going to explain what rules and regulations they relied on making their decision. And it's really important when you get the appeal summary that you read through it and you really understand it, because that's the entire position that they're going to be presenting at the hearing. And if there are things that you think are factually inaccurate or that you have evidence to the contrary, you're getting it 3 business days ahead of time so you have time to prepare. So let's talk about the hearing itself and what that looks like. So there are going to be a number of people at the hearing. If you show up in person, you're usually going to be sitting around a conference table in a conference room, and there's going to be a hearing officer. Some of the hearing officers are attorneys, but most of them are not, so don't feel intimidated by that. There's going to be usually at least one representative from the agency involved, whether that's Job and Family Services or the managed care plan. They may also have a legal representative from the Attorney General's office present or from the legal department of the managed care plan. In my experience, if they're going to have a legal person there, they're usually appearing by phone and they're not usually present in the room. And then you'll be there, and if you have one, you can also have your legal representative there. So it's usually, in my experience, 3 to 5 people sitting around a conference table having a conversation. It's not formal like what you see on TV for like trials and that sort of thing. But the hearing officer is going to usually open by turning on a recording device. They're going to make you raise your right hand and swear you in. They're also going to swear in anybody from JFS or from the managed care plan who's going to testify. And then they're going to start the hearing by explaining how they're going to conduct the hearing and what you can expect in terms of when they'll issue a decision. So it's really important to listen to that initial information. It's also important to know that because they're going to be recording everything that you say in the hearing, it's very important that you answer questions verbally. And I know that when we're nervous, it's easy for all of us to start nodding our head, right? Nodding yes, nodding no. Well, that answer is not getting recorded. So make sure that you're giving a verbal answer and that you're speaking at a volume that will be recorded. And if you don't remember that, don't worry. The hearing officer will remind you. But it is just an important tip to speak clearly and loudly enough that they can record your answers. So let's talk a little bit more. Usually the agency is going to talk and present their case first. So that may be JFS, that may be the managed care plan. You or your legal representative, if you have one, will actually have a chance to cross-examine them and their witnesses. And so what this means is you can ask follow-up questions, clarifying questions. If they've got something factually wrong, you can ask about that. If they misstate something, you can clarify that. After the agency goes, then you'll have a chance to present your appeal and why you believe the decision of the agency or the managed care plan is wrong. And if you want, you may have a hearing brief or a memo that outlines your argument. You can bring that with you. It's okay to use notes. You can't be expected to remember everything, but you'll have a chance to present your side of the story. Some hearing officers are very involved, and they're going to ask a lot of questions on their own. They're going to ask you questions. They're going to ask JFS or the managed care plan questions. Others are pretty quiet, and they allow the representatives to do most of the questioning. So a lot of times, if there's a legal representative for either Job and Family Services or the managed care plan, and you have a legal representative, a lot of times hearing officers will just let the legal representatives present the case, and they'll just kind of sit back and listen. Sometimes they're still involved, and sometimes they're still going to ask the questions, and legal representatives will just follow up with any clarifying questions. Both parties should be given an opportunity to do a closing statement at the end. So you can sum up your position and explain briefly why you think that the decision that was made was wrong. The managed care plan or Job and Family Services will be given the same opportunity. Do we need to break for a second? Are we ready for the
fine.
next
We are
slide?
ready.
Okay.
For the next slide.
Okay.
I was in a hurry there.
No problem. So most hearing decisions are going to be issued within 30 days of the hearing. Not always, especially complex or particularly challenging issues. You may get a decision a little bit after that. Some cases, I have them tell you right there in the hearing what their decision is because it's a very clear-cut case. You will get a written decision, but you may be told verbally during the hearing what's going to happen. So the hearing decision is either going to sustain your appeal, which means you win, or they're going to overrule your appeal, which means you lose. And the hearing decision should explain in really explicit detail what legal standard they used and why the hearing officer reached the conclusions that they reached. If your appeal is sustained, again, that means you won, there will likely be a compliance required. And this will be laid out at the end of the hearing decision. So compliance is where the hearing officer spells out in detail exactly what needs to happen next. So they're going to tell the agency or the managed care plan, you need to go back and redetermine this, you need to grant prior authorization, you need to authorize at least 10 sessions of this type of treatment, whatever compliance they think is necessary. If it's a delayed application, it may be you've got 5 days to decide this application. If it's a denial, they may say, no, you've got to grant them benefits. So that's what compliance is. It spells out very clearly what the other side needs to do. The agency has to complete the ordered compliance within 15 days of the hearing decision and no later than 90 days from the date of the original hearing request. So if things have been really dragged out and it's taken you a while to even get to a hearing and to get a hearing decision, so it's got to be at least within 90 days from the original request for the hearing and within 15 days of the hearing decision, whichever is fastest, so the fastest of those two. So what happens if you get a decision from the Bureau of State Hearings and it's adverse to you? You lose at that point. They overrule your appeal. You're not done. You still have options. And that is that you can file an administrative appeal. And this will go to an attorney that works for the state and it's nothing to do with anybody who made the original decision or who works at the Bureau of State Hearings who made the decision. So if your appeal is overruled, you may file an administrative appeal within 15 days of the date of the state hearing decision. Instructions on how to file the appeal are on the last page of your hearing decision, so it'll spell out what your appeal rights are and what the time frames and what to do. This appeal has to be in writing. Unlike other appeals, which I've said you could call and request or you could write to them, this one has to be in writing. It should state why you think the hearing decision was wrong. And you can either file a very simple request saying that, you think they were wrong and because they didn't consider X, or you can file a more formal memo that lays out the regulations that support your legal argument. So usually if you're doing this on your own, it's probably going to lean towards the more simple statement, but if you have a legal representative, they can actually spell out their entire legal argument in this request. There's not going to be any hearing at this level, so you're not going to go to another hearing on an administrative appeal. The administrative appeal is slowly a written process. So whatever you send to them in your request for an administrative appeal and whatever the record was below at the Bureau of State Hearings level, that's everything that they're going to use to make their decision. You're not going to testify again. The Job and Family Service Office won't testify. The Managed Care Plan won't testify. They're going to take the record as it exists. So let's talk about administrative appeal decisions. So your appeal is going to be reviewed by a hearing examiner. And again, this is an attorney, and they've had nothing to do with the original decision or the state hearing decision. They're going to review the hearing record, including the recording of the hearing, all the documents and evidence that are in the record, the hearing decision itself, and then they're going to issue an administrative appeal decision which addresses the issues or the fact and law raised in your appeal request. So whatever you raise, they're going to address it based on that record. The hearing examiner has options. They can either uphold the state hearing decision, they can overrule the state hearing decision and issue a brand new decision, or they can remand the case back to the hearing officer to conduct a new or supplemental hearing to get additional evidence that they think is necessary to make a decision in the case. So at this point, the hearing examiner is either going to say you win, they're going to say you lose, or they're going to say you're going back to the Bureau of State Hearings for another state hearing to get some additional evidence that needs to be developed. So any three of those can happen. If a case is remanded, you have a new Bureau of State hearing, and if you still get an adverse decision at that point, you can ask to go back up to the administrative appeals again. So you can go back and forth between those levels if your case is remanded. So what happens if you're denied at the administrative appeals phase? If you are denied at this point, you can still appeal, but you're going to be filing an appeal at this point in the Common Pleas Court. And the appeal will be restricted to the record that was created during the administrative hearing process. So you're not going to be able to provide any new evidence to the court. You're not going to provide any new testimony to the court. They really do just review the record that already exists and make a determination. Very few people appeal to the Common Pleas Court without having an attorney at this point. So the rest of all of this you can do on your own. You may or may not choose to have an attorney represent you, but when you get to the point of going to Common Pleas Court, almost everybody's going to have an attorney because it becomes very complex and you have to comply with all of the court rules and the formatting for pleadings, and it just becomes much more complicated. So at that point, I would definitely encourage you to talk to an attorney about representing you at the Common Pleas Court. So I know that was a lot of information that we just went through. So I want to open it up now and see if we've got any questions.
Thank you, Deborah. I mean, that is so helpful to kind of go over the tips and tricks and, the different processes in the appealing process. Let me see. If I have any questions. Do I understand correctly that if our family does not meet the financial eligibility requirements, then our disabled daughter will not receive receive any benefits that our hard-earned tax dollars go to fund?
Medicaid is a program for low-income families. And so if people are over the financial guidelines, Medicaid may not be an option. However, if a child is severely disabled and needs either the long-term care or the home and community-based services, financial eligibility guidelines are much more flexible at that point. But for the basic Medicaid plans, we're talking about low-income families. I gave you guys the federal poverty levels. That's very limited income for those families.
Okay. Would you be able to briefly go over BCMH and how it relates to Medicaid for youth? I'm not totally clear on the differences.
BCMH being?
Children for Medically Handicaps program.
Okay.
By the Ohio Department of Medicaid, yeah.
Yeah, so different programs.
Yes.
Different rules, different eligibility. And so that program really covers children who have much more severe disabilities, and it is much more flexible in its financial eligibility. So I've seen a lot of families who've been able to get a lot of support services through that program who have not been able to get them through traditional Medicaid, a lot of times because the family is essentially not financially eligible for the services. So this is a recognition that children with particularly complex or severe disabilities need some extra services, and a lot of times they're services that your employer-provided health insurance program or most insurance programs simply are not going to cover. I mean, things like respite care and attendant care services and those sorts of things oftentimes aren't covered. I don't think my insurance covers a lot of that stuff. And so this is a program that allows families to access some of those services without having to meet the strict Medicaid financial eligibility requirements.
All right. I don't think I see any more questions for today. Again, if there are any other general questions, and I'm happy to forward that to Deborah and get an answer for you all. We will have, I know a couple of you have asked for PowerPoint presentations. Can I share that with everybody, Deborah, the PowerPoint
Absolutely.
slides? Yeah. So I will email all the registrants the PowerPoint presentation, and I think we also have, hopefully we have the recording available as well, and we will work on the recording and post that on our website. Again, thank you so much. This has been so helpful to learn about the appeals and denials processes, Deborah. So thank you so much for taking your time and explaining to us Medicaid. Thank you all for joining in today. You all have a good day. Thank you. Thank you again, Deborah.
Thank you. Have a great day.
Thank you so much. Bye-bye.